My name is JONBENET Ramsey, and I'm 5 and a half.
What is your favorite animal at the zoo?
The monkeys, because they laugh and stuff and hang around.
I got nightmares in my head, I fear thoughts build up until I can't feel. My mind fills up into a creature, and it haunts me somewhere much deeper. I got nightmares in my head, thoughts build up until...
Hello and welcome to True Crime Rocket Science, the most authentic voice in true crime. This is episode 2 in the Khan's Order series, and as always when we're dealing with the Ramsey housekeeper, the evidence is dynamite. If you missed the first episode, the Khan's Order provides a glimpse of what could have happened had the Ramsey case gone to trial. Bear in mind that some of the Boulder police believed that Patsy was responsible. I think a very interesting thing to ask is, if you had to do a poll of the Boulder police, would there be consensus of who was responsible for what? I think it's an interesting question. Certainly one of the Boulder police detectives, Steve Thomas, believed that Patsy was, it appears, solely responsible. And so this is the information that Judge Khan's had to deal with when dealing with the guilt or innocence of the Ramseys vis-a-vis the intruder theory, the alternative theory. If you're enjoying this series, please subscribe to the channel, like, share, leave a comment, and let's get started. So we're going to jump right in with page 7 of the Khan's report, which I think is 93 pages. It refers to the plaintiff, and that's a reference to the to Chris Wolf, who was accused by the Ramseys in their book of possibly being involved in the crime, and he then countersued, or he sued the Ramseys for defamation. To defame someone, you've got to prove malicious intent, that you know that something is not true, but you say it regardless. So we kick off at a very interesting point on, I believe it is page 7, around about midway through page 7. Quote, relying solely on the testimony of Mr. Thomas, who has no apparent expertise as a medical examiner, and so this is obviously a bit of a snub at the detective. Plaintiff fixes the time of death at around 1 a.m. Now I've got to say that is also the True Crime Rocket Science estimate, that it was essentially between midnight and 2 o'clock in the morning, with the average being probably around about 1 a.m. You've also got to, if you're going to dismiss the intruder theory, you've got to look at, would there be enough time to do certain things? And that includes the writing of the Ramsey note, the cleaning of JONBENET, moving a body, and various other things. And so you need a time that is not too far from the time that the police were called, but also not too close to it. And so 1 a.m. or even 2 a.m. is giving you around about 3 to 4 hours to prepare. And you might think that that is a long time, but you also need some time possibly to find your bearings, to deal with the emotions, to understand what is going on, to orientate yourself, to decide what you're going to do, and then to do it. So I think time of death is a very interesting concept in the Ramsey case, just as it is in the Chris Watts case. It's a mystery in both cases, but it's certainly in the Ramsey case we do actually have some idea based on the digestion rate of the pineapple. Now, this is something I had experience with in the Reva Steenkamp case, Oscar Pistorius, where she also had a very small amount of semi-digested food, which suggested a certain time of death. And although there is some science involved, it is very difficult to be 100% scientific about something like digestion, because there's also post-mortem digestion. And I think in that particular case, the judge sort of threw out the evidence. I believe that Reva was shot also at around about 2 o'clock in the morning. between 1 and 2 o'clock in the morning. And the digestion in the Ramsey case also seems to bear this out, although it's very difficult to be precise, and it's unfortunate that the coroner didn't make any aspersions about that. That's something that is also interesting, that is missing from the autopsy, is an estimate as to time of death. The coroner spent very little time with JonBenet's body when he arrived. He arrived something like, I think, 8 o'clock at night or even later, and he was only with the body, I think, for 10 or 11 minutes. So, arriving at the residence 7 hours after the body was found, when the body had probably been, lying where it was for easily, the body was basically inside the Ramsey home for almost 24 hours before it was removed. And that is always going to make time of death difficult to figure out. But the fact is, even when they did the autopsy, they still found fruit matter consistent with pineapple in JonBenet's stomach during the autopsy. So even though the judge argues to some extent, differs to some extent with the testimony of Steve Thomas, calling him not a medical examiner, and in terms of referring to the time of death, it definitely is a difficult science. She nevertheless refers to the coroner's report indicating that vegetable matter consistent with pineapple was found in JonBenet's stomach. She goes on to point out the report does not establish a time of death based on the digestion rate of the unidentified matter. Now, what I think is quite unfortunate with the judge in this case is she dismisses what the detective says, but then doesn't seem to come up with any idea of her own. Now, on the one hand, you can say, and I have actually spoken to a judge about this, you've got to be guided entirely by the evidence. But I feel that there are certain cases where you're given a lot of pieces to a puzzle, and you can make certain inferences of logic, right? So a logical point to make is that JonBenet did die, right? And so you've got to make up your mind as a judge, even if the evidence isn't explicit, that it was either closer to this time or closer to that time. And there are quite a few cases where you've got to make that decision. Another one is the murder of Meredith Kircher. So she dismisses Steve Thomas's time of death, but then doesn't come up with one of her own. She simply just says, well, there's no evidence to support that, except that there sort of is. There's the pineapple found in her stomach, right? Then it goes on to say, plaintiff also theorizes based on the presence of the unidentified matter in JonBenet's stomach that contrary to Mrs. Ramsey's testimony, she was up during the night and fed JonBenet the pineapple, which I think is a very good point. This is then disputed. It's one of the plaintiff's statements disputing material fact. And I really don't know how you can say that. I don't know how you can say this is a plaintiff's statement disputing material fact when you've got somebody saying something. So saying, well, I put JonBenet to bed. I don't know how you can say that that is a fact. It's a statement. Anyway, there is no evidence in the record that indicates when JonBenet ate the pineapple. Defendants state they did not feed JonBenet pineapple upon returning home from the Whites' party that evening, and that's put again as a statement of material fact. So when you see something like that, I find it sort of riles me, because it's basically the judge saying, well, what the Ramseys are saying is gospel. So if the Ramseys say they didn't feed JonBenet pineapple, then she didn't eat pineapple. And so the fact that there's pineapple in her gut is like, well, just shrug your shoulders. I don't know what that means, because their word trumps all, right? I just find it, again, what I'm talking about here is the judges got to make certain inferences based on evidence. And although I agree that you've got to be guided by evidence, you also can't have what somebody says trumping evidence as well. And that looks to be what is the case here. I just want to refer again to the Oscar Pistorius case. You had a number of witnesses saying that they heard a man and a woman screaming, and then the judge trumped that by basically agreeing with what Oscar said, saying, well, the screams were all his. It was his screams, and he screamed like a woman, so there was no argument. It was just him screaming all the time. And the judge then trumped something like 5 ear witness testimonies, 5, that heard a man and a woman screaming, and decided she agreed with what Oscar was saying. And obviously he's going to try and defend himself, say something that is going to defend himself. And it was just really interesting that the judge took that position. So you have the same thing happening here, which seems to defy logic in a way. So, there's pineapple in JonBenet's stomach. If you understand the Ramsey case, you know that she didn't eat pineapple at the Whites or at the Steins, or I think at the Walkers. And so then where else could she have eaten it? And so, but this doesn't seem to be really addressed. This is addressed. Mr. White does not recall if pineapple was served at his dinner party on December 25th, 1996. That's from the Fleet White deposition. So maybe because that's not a very strong denial, I don't remember if pineapple was served. But I think there are other people who perhaps do remember, such as Priscilla White. She might remember, since she served dinner. I also think you've got to think about the constitution of fruit, and you've got to think about, if you're eating a dinner that consists of lots of different things, why would the fruit remain when something that has got a greater, the bulkiness of the food is more difficult to digest, something like crab meat, right, or anything like that. And so anyway, you've got the pineapple that is still fairly high up in JonBenet's stomach. I think it was in the duodenum, so it's not even in the small intestine. Now, if you bear in mind that normally digestion can take 2 to 3 hours, it really suggests that whatever happened to JonBenet happened within an hour, really, of her eating the pineapple. And that also is something that I kind of thought was laughable, the scenario where JonBenet put something into her mouth and was then struck over the head and killed. If that was the case, there would still be pineapple in her throat or very high up in her stomach. The fact that it was as low down as it was seems to indicate that she hadn't just eaten it. She'd eaten it perhaps 10 minutes before she died, perhaps half an hour, perhaps even an hour. An area where I tend to agree with the judge's assessment is the notion that Patsy did something. She perhaps pushed JonBenet in Steve Thomas's scenario. JonBenet was struck very hard, perhaps falling against a bathtub or something. That is his scenario. Perhaps, I know a scenario that I considered early on was that she may have fallen by accident down the stairs and hit her head on the edge of a stair or on the railing of the stairs, in terms of an accidental death, or a semi-accidental death where she either tripped or was pushed in a playful way or whatever. But in any event, in this scenario, she's still alive. There's this faint heartbeat, and though she was unconscious, in Steve Thomas's scenario, rather than being grateful that JonBenet was alive, Patsy decided to finish her off by making a garrote from one of her paintbrushes, looping the cord around JonBenet's neck and then choking JonBenet to death. And I think what is not mentioned here is also making the cord around the wrists, putting them loosely on. Now, what makes sense from that crazy assertion is that Patsy would know about her own paintbrushes, right? What doesn't make so much sense is I don't think Patsy would have been very au fait with knots. Certainly not as au fait as perhaps other people in the Ramsey household or the intruder. Now, I've heard some variations on this, that Patsy or somebody else found JonBenet in the position that she was in and then post-mortem applied the garrote to make the crime appear almost like an adult execution, almost like an assassination. The garrote is something that an assassin might use. And so after she had died, that someone had done this strangulation staging. I've heard that. I find it quite fanciful, to be honest. You could argue that the ransom note is even more fanciful, but at least the ransom note is something that Patsy, for example, she was familiar with. She was someone who wrote. She was a journalism major, and it's to do with expressing herself. I don't think that kind of thing falls into her portfolio or her skill set. Does that make sense? So to quote further from the Khan's order, plaintiff notes that the fact that JonBenet was choked from behind is consistent with the murder being committed by someone who knew JonBenet and did not want to look at her face as he or she killed her. I think this is something to think about in the Chris Watts case with Shanann. I think that is relevant. I don't think that this is relevant in this particular case. I think it's imaginative, but I don't think it's accurate. I don't think that whoever did choke JonBenet meant to choke her. I think it may have been meant as a restraint, but a restraint more symbolic in nature. And I certainly don't think that the garrote should even be called a garrote. I think it should be called what it was actually designed to be, which is perhaps a toggle rope or something else. So going back to the Khan's order, after murdering her child and staging the crime, plaintiff opines that to cover her tracks, Mrs. Ramsey must have taken the items she used in the staging out of the house, perhaps dropping them into a nearby storm sewer or among Christmas debris and wrapping in a neighbor's trash can. And this is also recorded here as plaintiff's statement disputing material fact. Again, I'm not quite sure what to say about that, disputing material fact. I don't know how you can prove that that didn't happen. I don't necessarily think it did happen, although I think you do need to think that if the nylon cord did come from the home, if the duct tape did come from the home, how could one or would one dispose of it? I think there are many possibilities given the scale of that house, given how ramshackle it was. I recently came across some photos of the mail slot which had burn marks or burn singeing on the wallpaper, and the first thought that I had when I saw that was, well, couldn't this have been a possible area where some important items could have been incinerated? Of course, it turned out that the fire was actually started after the fact by a fellow called James Michael Thompson, 33 years old. And this happened around about June 1997, so about 6 months after the crime. He shoved burning papers into the mail slot opening of the Ramsey home, and he was later, I think, charged. He was arrested and charged, and I think in connection with arson. Interestingly, Thompson was also in court on charges of theft and criminal mischief related to the removal of log sheets pertaining to JonBenet, her being admitted to the Boulder Community Hospital morgue. I'm just saying it's easy 25 years later to look at some of the crime scene photos and draw inferences that aren't accurate. For example, the fire that was made in the mail slot had nothing actually to do with the crime scene or the Ramsey case. What I think you can anticipate is in the middle of winter there might be a fire made in the fireplace, just as Chris Watts made a barbecue on the night that the crime happened. And you can imagine that certain evidence might be disposed of in a fire that you would expect to be active, right, as part of just the fabric of that day. So Chris Watts barbecued. I wonder whether the law enforcement looked in the barbecue for signs of burnt plastic, for example, an oxycodone container or piece of paper, whatever. Perhaps cards that Kissinger had sent to him or whatever it is. In the Ramsey case, it's possible that something similar happened, that debris was put into the fire. And if that's also the case, you can imagine in the 3 or 4 hours that it was possibly available, that in that time you could possibly start a fire, use the fire potentially for illumination, soft illumination, but also use the fire for disposing of certain items. I believe a brick or some object like a brick was recovered from the fireplace and tested for evidence, which I think is quite interesting. And there's some people who speculate that a red clay brick was actually the murder weapon. This also led me to ponder whether JONBENET could have just been riding on the pathway on the outside of the home, the front of the home, which is sort of curved, and there's an elevated section there, and if she'd fallen against that, that could also have caused serious injury. Steve Thomas refers to this brick on page 44 of his book JONBENET Inside the Ramsey Murder Investigation. So he refers to several items that they thought were possibly used to bludgeon JONBENET, causing the head wound. And one of them was, and this is quoting from page 44, quote, "A red clay brick that appeared to have fibers stuck to it was retrieved from the living room fireplace." Right? And then they also found a baseball bat with a blonde hair. This was later corrected to red carpet fibers, not blonde hair, found in the backyard. Now, I want to touch on this really interesting point. Is I'm not sure I've heard too many people talk about this, but the one neighbor heard a scream, but somebody else heard the sound of what they thought metal clanking on cement, or metal clanking sound. And I've thought that this could have been a bicycle falling over on the road or something like that. That's the one possibility. And another possibility is that someone may have tossed a baseball bat, possibly, or a aluminum softball bat, or a even a golf club, but more than likely I don't think a golf club would have made a very loud sound, whereas the hollow aluminum of a softball bat clanking on the ground beneath the home, the paving beneath the home, may have made that sound. And so when you make the argument that, if you think about the Ramsey home as this island surrounded by sort of virgin snow, and you can't go out because you're going to leave footprints. Well, one possibility to deal with that situation is you can open a window and perhaps toss something out. In other words, get something out of the crime scene without actually leaving the crime scene. So where Steve Thomas talks about someone putting something in a stormwater drain or in neighbors' garbage or something like that, I don't think that is likely, simply because I do put some stake in the no footprints in snow story. You could of course have a situation of someone going out and returning before the trace snow fell. I just don't put much stake into that. So you could have a situation of someone tossing the duct tape in the air, through the air, into a neighboring garden. I don't think that is likely. I think the most likely possibility is something like incineration, but there are other possibilities too, like flushing down a toilet. It could also have been smuggled from the crime scene either by certain people or by someone who came to the crime scene subsequently, and we know that something like that did happen, I think on the 28th of December. I think Steve Thomas described it as a one-woman raid of the crime scene. I see we're coming up to the 25-minute mark. I don't want to take it too much further than that, just other than just to note that it is a problem with the Ramsey case that we can't source the particular duct tape really to the Ramsey home. That is definitely something that seems to shift the the weight or the target or the arrow of possibility away from the Ramseys. The other thing is that the nylon cord, I think, is less exculpatory, but I still think the fact that you couldn't find something similar to that cord, I think the closest they found was a cord attached to the toy aeroplane, model aeroplane in Burke's bedroom, but I really doubt that that would be the same material. Even though you can't trace it, I think the fact that duct tape is regularly used by artists. My brother's an artist. He regularly uses duct tape to in the framing of his artworks. It's regularly used by artists, and also that cord, that nylon cord, is something typically used in camping, and perhaps something that Scouts would use. When you go through a Boy Scouts handbook, you can see just to what extent strings and ropes are used in different applications. So what I think would be very interesting is to ask if that cord wasn't found in the home, was any cord found in the home, and if no cord was found in the home, I would find that quite strange. So we go then to just the bottom of page 8. It refers to the sources for the duct tape and cord were never located nor sourced to the defendant's home. That's quite a strong point. Plaintiff claims that Mrs. Ramsey next placed the ransom note in a place where she would be sure to find it. So I think that is quite an interesting point, is that if you're making the claim that Patsy wrote the ransom note, she needs to stumble upon it, right? And I think that is certainly quite an interesting idea. I think it has another bearing as well. I think the bearing is who else could have left it there, and who would have left it in that particular location. I've got a feeling the ransom note was left where it was, partially to contaminate it, because that is the den area is exactly where the adults gathered on the Christmas party of the 23rd, right? So I think contamination of the note was one idea. I think the other idea was that I think the housekeeper would typically come in through an entrance near the spiral staircase. And I think one of the first things she would do is go up the spiral staircase to attend to JONBENET's bedding. But that, I think, would certainly be a route that she would take. So I think that is another thing to consider. Then the word sourced is used by the parties as a verb. Some nitpicking here. When a sentence indicates that a particular item was not sourced to the Ramsey home, it means there is no evidence that those items were ever in the Ramsey home at any time before the murder. Then we go to page 9, and I'm not going to take it really much further than this. Mrs. Ramsey disputes the above recitation of facts. She claims that upon waking, she put back on the same clothes she had on the night before and applied her makeup. She then states she went downstairs to prepare for their departure on the family trip. This is put down as statement of material fact. Now, what I find quite weak about all of this, and I think it's because Darnay Hoffman wasn't able to appear on the day that this needed to be fielded in court. So I think the judge just simply took the words of Linwood at face value. There's nothing mentioned here about Mrs. Ramsey having two different versions of events. For example, I think her first version was that she first went into JONBENET's room, then found the note, and then it was the other way around. I think there was also, I say this under correction, but I think there was also stairway that was used, and then later on it wasn't used. Then it says, as she descended the back stairwell, she discovered the ransom note. I suppose back stairwell refers to the spiral staircase. I just don't think it's stated very clearly, and I think that's a problem. She discovered the ransom note and read only a few lines stating that JONBENET was kidnapped but safe and unharmed. I think, again, you can argue here that why would you only read a few lines when this is the clue to what's happened to JONBENET, and then demanding $118,000 for her return, $118,000. Mrs. Ramsey immediately screamed and proceeded to check JONBENET's room, which was empty. What's interesting here is there's nothing about screaming for JONBENET. She doesn't call for JONBENET, and she only checks JONBENET's room. After hearing Mrs. Ramsey scream, Mr. Ramsey ran downstairs and met Mrs. Ramsey in the stairwell. Again, in this scenario, you've got to say, well, what about Burke? Wouldn't Burke also hear the scream and come running? Together they checked on their son, who appeared to be asleep in his room. So Mr. Ramsey hears the scream. Now this is a analogy for the scream that JONBENET supposedly made in the basement. You hear John hearing the scream apparently from the top floor, but Burke doesn't in a floor below. Together they checked on their son. Mr. Ramsey then went downstairs to read the ransom note, and what's not mentioned here is that he apparently went downstairs in his underwear, and then he sort of was in a crawling position when he read the note. He didn't actually pick it up. This is something else that Dana Hoffman could have said if he was present. He could have said, don't you find it interesting that neither of the Ramseys ever appeared to handle the note? And then the judge probably would have said, well, where's your proof? And he would have said, well, there's no fingerprints. The judge probably then would have said, well, that doesn't prove anything. It doesn't mean, if there's no fingerprints on the note, does it necessarily mean they didn't handle the note? So anyway, Mrs. Ramsey called the police, informing them that her child had been kidnapped. In addition to calling the police, defendants called several friends to the house, including Fleet and Priscilla White, who promptly came to the defendant's home. Now what's interesting is they don't name who came. It is also the Walkers, and also the Fernies, and also the Reverend. Maybe that should be mentioned. Defendants did not heed the warning in the letter that stated, the two gentlemen watching over your daughter do not particularly like you, so I advise you not to provoke them. Speaking to anyone about the situation, such as police, FBI, will result in your daughter being beheaded. If we catch you talking to a stray dog, she dies. If you alert, she dies. That's actually lines from a movie, but we'll get to that in due course. And now we're going to deal with a section that deals with the title of this video. And this is from page 10. Plaintiff contends Mr. Ramsey probably grew suspicious while reading the ransom note that morning, which surmise is again based solely on the opinion of Mr. Thomas. Again, I don't really agree with Steve Thomas on that point. Plaintiff speculates that upon examining the ransom note, Mr. Ramsey must have seen his wife's writing mannerisms all over it, everything but her signature. That's put down as plaintiff's statement disputing material facts. Upon determining that his wife was involved in JONBENET's disappearance, plaintiff surmises that Mr. Ramsey chose to protect his wife rather than to facilitate the capture of his daughter's murderer. Mr. Ramsey asserts, however, that he never once suspected his wife to be involved in the crime. Now, all of this is fair and well with the judge not being aware of what is in the indictments. Now we coming to the end of this. It's a little bit longer than I thought it would be. Plaintiff seeks to introduce the testimony of Linda Hoffman Pugh, who worked for the family as a cleaning woman for nearly 14 months prior to JONBENET's death, and who asserts the Ramseys had a troubled marriage. Now I find that quite interesting. I don't know why they don't just refer to her as the housekeeper, but it is interesting that she's entered into this case as saying that the Ramseys had a troubled marriage. Now you've got to wonder, what does that mean? What does it mean to say troubled marriage? If you say Chris Watts or the Watts family had a troubled marriage, what does that actually mean in terms of specific detail? This point is noted as plaintiff's statement disputing material facts. So the Ramseys claim that they didn't have a troubled marriage. The Khan's order goes on to say, Ms. Hoffman Pugh states that Mr. Ramsey berated Mrs. Ramsey for being a lousy homemaker and cook shortly before the murder, and that the couple never once demonstrated any affection for each other, physical or otherwise, in front of her. That's also put down as plaintiff's statement disputing material facts. Defendants strongly deny any such marital problems. And then you also have defendants objected to such testimony as inadmissible based on a lack of foundation and general irrelevance. And I don't really know whether the judge dismissed it as inadmissible, but the fact that it's mentioned here seems to show that the judge did put some value into it and did take it into consideration and also found it to be relevant. What is interesting is what she writes at the bottom of the page: the court will consider Ms. Hoffman-Pugh's testimony. In other words, there's been a lot of her saying, okay, the Steve Thomas said this, the plaintiff said that, no, there's no evidence. But this statement from Linda Hoffman-Pugh seems to carry some weight. And it seems as though the judge, who's a female judge, is wondering, well, could it be true? Is it possible that Patsy wasn't a great homemaker and not a very good cook? Bear in mind, the whole family ate out twice a week at Pastor Jay's, and the house was definitely in disarray. You can see from the crime scene photos, JONBENET's room was in disarray. There's even talk that John made Burke's bed, but there's the sense that the house was in disarray at the time that this crime occurred. And bear in mind, in the JONBENET series, I've put forward the narrative of neglect. How relevant is that? How real was that? It does seem to be something that the grand jury felt was of significance, doesn't it? So the plaintiff responds that Linda Hoffman-Pugh's testimony is relevant on a point placed in issue by defendants through their assertion that no marital problems existed between them, which I think is quite interesting. What I think is an interesting counter-argument to that, if you say no marital problems existed, is the Ramseys went on to write a book together. They remained married for another 10 years, I think. And then, the marriage only dissolved because Patsy died in 2006. And so the question sort of comes up, if Patsy didn't die, would they have stayed married? What would have happened? I do think you've got to look at Patsy and John in the interviews that they gave together on CNN, on Larry King, with Barbara Walters. You never once really see them holding hands. They virtually never touch one another. They very seldom look at one another, but there nevertheless seems to be a great solidarity between them in terms of dealing with what is going on. Wouldn't you agree? So I'm going to end it there. I know I sent it about 10 minutes earlier that I wasn't going to take it further than that, but I don't think it would have been great to have an episode titled, something about the housekeeper and then not quite get to that. So that is where we end off with the first 10 pages, with the court saying, and that this was a sort of a minor victory for the Steve Thomas, Chris Wolf side of the argument, that the court accepted and decided that she would consider Miss Hoffman-Pugh's, the housekeeper's, testimony. Thank you for listening. I hope you guys have a great weekend. Stay safe wherever you are. If you haven't subscribed yet to the channel, please do. Like, share, leave a comment, and I'll see you guys next time.